The High Court has recently refused to confirm the appointment of an interim examiner to a special purpose vehicle set up to develop commercial property in what the court described as an unprecedented application. The company had borrowed around €54 million to acquire and develop a site in Dublin, but after falling into insolvency and the appointment of receivers to it, it urgently sought the court's protection and an interim examiner was appointed to it. What's interesting about the decision is that even though the court was prepared to assume that the company had a reasonable prospect of survival, it refused the application on the basis of the exercise of its inherent discretion to do so. In circumstances where the company only had 2 employees, the focus was on whether this was the kind of company that examinership is really intended to protect and whether the court should exercise its discretion in the company's favour. Mr. Justice Toomey made it clear that examinership is designed to support a real trading enterprise whose survival serves the wider economy and helps preserve genuine employment. On the facts, he did not regard this SPV, whose only employees were its 2 investors, as fitting that description. The court was also critical of the company's conduct. It found that there had not been the required level of utmost good faith, pointing in particular to the failure to disclose an earlier valuation report and to the transfer of funds beneficially owned by the secured lender shortly before the application. The decision should not be read as shutting the door on SPVs or companies with modest employee numbers from availing of examinership. Rather, it's really a reminder that practitioners ought to very carefully consider if it can be demonstrated to the court's satisfaction that the company in question is a real enterprise with real jobs, in the words of Justice Toomey, and that appointing an examiner would, on all of the facts of a particular case, be for the general economic welfare of the community.